Gentlemen, we are moving on to our next session, which will be presented by, again, an eminent speaker. So let's call upon my colleague, Amit.
Thank you very much, Shweta. What an interesting session we had on innovation. Thank you very much, sir. And thank you, CA the NMSG, for doing the honors. So our next session is on the topic taxation in the new global era. We all will agree that taxes help spur economic growth that in turn have a ripple effect on the country's economy. The session that you're going to witness now here in the Jasmine Hall of Geo World Convention Center would dwell upon the impact of taxation in the global era, characterized by the economic, political, and socio-cultural interconnectedness. And we have two very distinguished luminaries with us for this session. May I invite CA Ved Jain on stage, please. Honorable past President with the Institute of Chartered Accountants of India. And also, it's an honor for me to invite Mr. Arvind Datar, prominent senior advocate. Please welcome both our guests with a huge round of applause. Mr. Arvind Datar is a specialist in tax, company, and constitutional matters and has to his credit many highly regarded legal commentaries. And Ved Jain, sir, is a direct tax luminary. So we look forward to this session on taxation in the new global era. First, I'd like to invite Mr. Arvind Datar, prominent senior advocate, for his address. Arvind ji, please.
Good afternoon, everybody. I must thank Dr. Mitra and the entire team from the Institute of Chartered Accountants for inviting me to this landmark event of the World Congress of Accountants. I'm told that it is held every 4 years, so this is indeed an event of Olympic importance. I listened to the lecture of Mr. Desai with great interest. His talk on innovation, sustainability was very encouraging. And I think he has rightly said that the future of chartered accountants is very bright. And I fully echo his sentiments, not only in the field of chartered accountancy, but also in the field of law. I think one of my favorite sayings is that the tragedy in life is not aiming very high and missing, but the tragedy is aiming low and hitting. So I wish all of you all the very best in the future. Follow what is called the 10x rule. It is said that the best way to improve the present is to visualize a bigger future. So I'm very, very happy that I could hear Mr. Desai's lecture. Now, the topic for today is taxation in the new global era. And Mr. Desai also mentioned to reflect on our journey in the profession. And before I start my topic, I know we are running late, but just... Okay. Thank you. I was just sitting here and reflecting on the last 40 years that I've been a lawyer, and how much technology has transformed our lives. Just a few minutes and then I'll get on to my topic. When I wrote my first book in the late 80s, my first book came out in 1988. I started writing in 1986. And those young members of the audience will be surprised, if not shocked, to note that we did not have a courier service from Chennai to Nagpur in 1986 to 1988. My publisher was in Nagpur, Vadhva and Company. And you'll be surprised to note that everything was typed, computers had just started, and the manuscript chapter-wise was sent to Nagpur in a very remarkable way. Every night the Tamil Nadu Express leaves for Delhi. So we would take the proofs, my wife and I would go to the station, put the proofs of the manuscript in a cloth bag, give it to the pantry car waiter, and then come out, stand in the line for the STD booth, try to connect a call to Nagpur, and tell my publisher, Mr. Wadhwa, Pandian in pantry car waiter has got the parcel. And the same way it would come in return. And now today we have got a system where the entire book is sent digitally, proofs are digital, any change is made automatically everywhere. I still remember when I used to go to Nagpur for the proofs, the negatives used to be dried in solution, and if you make one mistake, the whole negative had to be scrapped. So I tell my young colleagues, my interns, that you have got, the world is your oyster. Technology is so useful that your progress is extremely enhanced by the use of technology. Now, coming back to taxation in the digital era, it is amazing that those of us who are born in the second half of this 20th century have seen technological transformation never seen before in history. From the mobile phone, the cyclo-styling machine, and the other methods of work, we have come to such an advanced stage. And with the breathtaking increase in technology comes challenges in law and then by taxation. If you have studied the contract law, most of you have passed chartered accountancy, would have studied the contract law. In fact, I may add on a personal note that I was teaching in the Institute of Chartered Accountants in the Southern Region Council from 1981 to 93. And whatever tax I learned was learned by teaching there. And one of the happy moments of my life is when I'm at the airport or some particular place, a person comes back and says, "Sir, I was your student in 1989, I was a student in 1990. I'm surprised that he passed the exam in spite of my teaching, but then it's a gratifying feeling that my students are doing so well. Now, coming back to the subject, my topic is taxation in the context of indirect taxes. Mr. Jain will deal with the direct taxes. Now, as far as indirect tax is concerned, if you take the first slide, the BEPS Action Plan 1, those of you interested, can read chapter 8 and 9, and also annexures C and D, which deal with indirect taxes. Now, it is surprising that though it's called Action Plan 1, the annexures C and D alone run to 100 pages. So almost 1/3 of this action plan of 290 pages is covering indirect taxes, though chapter 8 and 9 deals with it. And they point out various challenges of the indirect taxes. The most important challenge now is to allocation of taxing rights. Who gets the right to tax? Is the taxing right with the supplier, where the supplier is resident, or whether the taxing right is where the customer is the recipient? That is a major problem, and I'll come to the law a bit later. But one point to be sorted out is which country gets the taxing rights. Indirect taxes, as per the OECD model, is basically consumption-based, destination-based. So typically the country where the service is received gets the right to tax, although this may not always result in equity because the country where the service is actually generated does not get the right to tax fully. One answer to that is the country where the supply is generated, say for example a movie is made or a music video is made, there all the work is done and a lot of the input credit also is generated there, but the recipient country gets to tax it. So there are going to be complicated issues that if the work is done in country X, but the tax is in country Y, what happens to the input tax credit? Who gets to tax it? And so on and so forth. So this is a short session, so I'm not getting into the complications, but a major challenge is going to be the taxing rights vis-a-vis the supplier country and the consuming country. Now, there is another major problem highlighted by the OECD. A large volume of B2C transactions are low-value transactions, which are normally exempt or very low tax is levied in the country where the supply is generated because the quantum of tax does not justify the administrative cost. So they say that since the value is low, the tax is low. Now, if the tax is low and it is consumed in the other country, who gets the right to tax it? Now, this is the second challenge as far as we are concerned. Now, if you go to the next slide, the other major problem, which is highlighted by the international VAT guidelines, what we require today and where the major confusion is There are no standard definitions of what is the meaning of place of supply. There is no standard definition of what amounts to consideration. No clear definition of what is subject to GST or VAT. VAT is also synonymous with GST. Our definition is very wide. Other countries may not be so wide. So these are all problems. And my suggestion is, in this World Congress, that just as we have a double taxation avoidance agreement for direct tax, it is perhaps time that we have a DTAA for indirect taxes also. The guidelines have come from 2006, 2009, there's the Ottawa Congress. We've just been having guidelines after guidelines and some discussions, but nobody, it's time to bite the bullet and say, let us have a double taxation avoidance agreement for indirect taxes where we standardize definitions, place of supply, consideration, and allocation of taxing rights. This, I think, is the need of the hour, and if one message can go from the World Congress to the powers that be, it's time that countries sit together and start drafting a double taxation avoidance agreement. For a start, either the OECD or the United Nations can draft a model treaty which can then be adopted. It will be difficult to have a multilateral treaty, but it will be important to have a bilateral treaty. I've been reading some articles in the British Tax Review and some journals, and there has been a lot of criticism of countries indulging in what is called competitive taxation, going beyond the jurisdiction to collect more revenue. And this grossly distorts the allocation of taxing rights and leads to double taxation. So a double taxation treaty will really sort out this problem. Now, I'm just coming to the Indian example because I know it's a World Congress. We are dealing with macro level problems. But I'm taking India as an example of what one country can do to harmonize the international taxation of indirect taxation of supply of goods and services. As far as goods are concerned, there is not much of a problem because they are physical. They can be subject to Customs Act, VAT, and so on. The major problem, as we all know, comes in digital goods and digital services. They say it's virtual presence. Actually, virtual presence is an oxymoron. If you're virtual, then you have no presence. But then we use the word virtual presence. Now, what has India done? This is the issue which is subject to so much of litigation. The online information and database retrieval service, what we call OIDAR. And what they do is, if you've got services which are based on the internet, with minimal human intervention, then these are online services, and the place of supply is where the recipient locates. So if it's online gaming, online educational services, online advertising, and so on, they're given 7 categories. I've given the illustrations. Cloud services, e-books, music, software. All these are subject to Indian taxation because under Section 13 of the IGST Act, the place of supply will be where the recipient resides. Now, this leads to a lot of practical problems. The government has announced a scheme where foreign suppliers can register in India. Today, as of my information, about 317 people have registered at Bangalore, which is the place for registration. But a large number of medium, like Mr. Datar was saying, medium enterprises, small enterprises abroad, they don't have the time or they are not interested in registering. Now, the section further provides that a foreign e-commerce operator must register. If he cannot, he must employ a representative, or he must appoint a person who will pay the tax on his behalf. Now, there is a wonderful book called Public Law of International Taxation by Professor Qureshi, and he says that, look, you can make these laws, but if they can't be implemented, it's of little use. So you may tell the foreign person you appoint a representative, and if he doesn't do it, what is the consequence? Now, this can happen to various countries, and if the person doesn't comply with, there is very little that the recipient country can do. Now, the next, yes, that's what I mentioned, electronic commerce, physical presence, special appointment. Now, the place of supply is another major problem as far as indirect tax is concerned, making it the place of the recipient of service. Now, one other problem has come as far as we are concerned. I'll come to the next problem. One major problem which will come in all countries, internationally, is taxing services which take place outside your country. Now, there is a principle of international law that every country has a sovereign right of taxation. In direct taxes, we say the taxation can be source-based or residence-based. There's no difficulty on that. In indirect taxes, it can be supplier-based or customer-based. This could be two possible things. But the problem which is not yet sorted out, it's still at large, is what is the power of a parliament? I'm just taking India as an example in this World Congress. What is the power of the Indian Parliament to tax something which is taken abroad? And the recent judgment of the Supreme Court has sorted out a problem to a limited extent, but the main thing remains unresolved. This was the classic case of ocean freight, where by notification, GST was sought to be levied on ocean freight or transportation costs incurred outside India. So suppose I buy a machine from Japan or from Germany in a CIF contract, where the contract price includes cost, insurance plus freight. Now this item has suffered tax in Germany, freight has been arranged by the German party. The taxable event is the freight, the supply of services, transportation service. That has taken place outside India. Can India tax it or not? Now, I've been working on this in my own way. Article 245(2) of our Constitution says, a law will not be struck down merely because it has operation extraterritorially. But there is a vast difference between extraterritorial operation and extraterritorial legislation. There is no time today to discuss it. One of the quirks of the thing was this question whether Indian Parliament can tax something outside India was referred to 5 judges in the Electronics Corporation case. Unfortunately, when the matter came for final hearing, Electronics Corporation withdrew its petition. So that question never got to be decided. So sooner or later, Parliament has to be decided, and that will have international ramifications. How far you can tax a taxable event which occurs outside your country. The whole point is, as far as extraterritorial legislation is concerned, how far it can be implemented is one of the main questions which has to be answered by the courts. Now, the last point which I'm going to deal with is equalization levy and GST. We have now equalization levy on online goods and services, on e-commerce operators, and the taxes on the consideration which is payable to the e-commerce operator, where the online goods and services are given to a person in India. I'm not going into complications, but by and large, if an Indian recipient gets online goods and services, then the e-commerce operator has to pay the tax of 2%. Initially, there was a controversy whether it will apply to physical goods, because the definition was online commerce includes placing the order, purchasing the goods, paying the money, etc. Fortunately, I had the occasion to write an article saying it will apply only to digital goods and services. And to my surprise, the finance minister made a tweet, I think before Elon Musk took over, made a tweet that this is the view. And at the moment, at least, there is no question of taxation on physical goods and services. But the point I'm making today is equalization levy is really a kind of double taxation. The same goods suffer IGST when they come into India if it's OIADR, and the same goods again suffer equalization levy. Now, these are two problems which have to be sorted out. Again, as I said, the double taxation avoidance agreement will be there. So I've just finished my lecture. Thank you very much for giving me a patient hearing. When I was invited, I forgot to mention this, when I was invited, I readily agreed. I was born in Bombay. I studied in the Ruya College. I did my schooling in Pune. So this is as much as a home. I'm as much as a Marathi Manus as anybody else. And one very nice thing happened this morning when I landed from Chennai. The flight attendant said, he didn't say welcome, we landed at Bombay. He said, Sapno ki nagari mein aapka swagat hai. Welcome to the city of dreams. And I'm happy that the World Congress is held in Bombay. I've always felt a kind of an energy, a kind of vibration in Bombay, which is invigorating. Every time I come to the Bombay High Court, it's always been a very wonderful experience. It's also been wonderful to be in this magnificent auditorium on a global scale, and I wish you all the very best. Thank you.
Thank you very much, Mr. Arvind Datar, for that illuminating sharing of knowledge. And I now request CA Ved Jain, past President, ICAI, to please share his address.
Sitting on the dais, a luminary, legend in his own way, Mr. Arvind Datar. In absentia, Mr. Harish Salve was supposed to speak here on direct taxes. Because of the last minute change in the program, I have been asked to speak on the issue of the direct taxes. Past presidents, council members, president of the ICAI, vice president, delegates, brothers and sisters. It's my proud privilege to be here and to talk about with you on the topic of this session, a new global era in taxation, where we need to look economic, political, and socio-cultural interconnectivity. When we talk of taxation, let me first just talk about what some fundamental principles of taxations. We all know taxation is the cost of civilization, which each one is supposed to contribute according to its ability to pay. We all know taxation is a sovereign right with the government of the day. It's a sovereign right of government. We all know taxation should be simple. And when we say simple, it must depend on ability to pay. The person who is required to pay, there is the ability to pay. There is a certainty. Certainty means there is a clarity in the provision. The taxpayer and tax administration understand what is the obligation of the taxpayer and what tax administration, how to collect the taxes. And then there should be a reasonably a good system of how to address the disputes and the litigation which arises. That's the one efficient way of what we call a taxation. At the same time, we know that taxation over a period has been used by the various state governments in order to achieve certain other objectives which are sought to be achieved by collection of taxes. When a government of the day collects taxes, it collects taxes just to provide security, safety, to meet administrative expenses, at the same time to address various social welfare projects also. But if the sovereign government of the day believe that in case that social welfare objective can be achieved by some other means, by giving concession in taxes, then the government will like to provide those concession in taxes rather than collecting taxes. And across the globe, this strategy has been used a number of times in different manner and different ways. And if I look from the Indian perspective, how we have been over a period providing the various socio-economic objectives we're trying to achieve through the direct taxes. Late in 60s and 70s, the country was short of the foreign exchange. We introduced a provision that in case you export goods, you export services, there will be no tax. The export was never supposed to be exempt, but the government of the day thought fit, the exchange is more precious than the taxes which I will collect, and that's why I'm to encourage I do it. Similarly, when we want to encourage achieve some geographical imbalances to remove it, the government of the day came out with the various provisions that particular area, if you put up an industry, the income will be exempt in order to encourage investment in that area, to encourage employment in that area. Similarly, the government of the day thought that one particular type of industry which India is interested, which India want more and more to produce, more to do, we have exempted that income, maybe power, electricity, telecommunications, IT sector, whatever infrastructure, the various exemptions have been used for that purpose. Similarly, government of the day have used to attract investment from time to time from various adopting various means, saying that in case you invest, you bring the money, we will not tax you. And that has been used politically also. And one of the best example, if I believe, the political connectedness with the direct taxes have been the Mauritius Treaty, which India entered way back in the 80s. When we said that if you make an investment through Mauritius, the capital gain will not be chargeable to tax in India because the treaty provided it will be chargeable to tax in Mauritius only. That's a phenomena which we had been used. And that time, movement of goods were mainly physical over a period that has moved in. And this phenomena continued and various countries have been using it. But sometime as we move forward, the thought process changes. The tug of war, which we call between the developed and developing nations, that starts working it out. And that brings me to the point, I being an old science student, before I joined chartered accountancy, the Darwin theory of survival of the fittest. Everyone tries to outsmart the other in order to survive. And in order to that, the human nature also comes in the foray immediately. I want to encroach upon others' area. Now, in order to expand the tax base, each country tries that what can I do beyond my borders I want to tax. Border being physical, so only when deeming fictions were created, let's go, move out, we will tax something which goes out. So something which is happening there, I created a deeming fiction, intangible came, royalty came, FTS came, so many issues came up and this I would like to tax it. And having done so, then we face the problem, issue of a double taxation. First we make a provision that I will tax it, then we two countries sit together across the table and say, all right, let's have a double taxation avoidance agreement. We define which country will have the jurisdiction to tax particular income, and in case that income gets taxed in the other country, I will give credit for the taxes. That's one objective which was achieved, and it was possible mainly because we were in a more physical world. But post-80s and post-90s, the world has moved a lot. And now it is a digital economy and digital way. And the last 3 years, I will say, post-COVID, has shown everything will be now online. You can have e-commerce, you can have e-delivery, you can have your food, you can have your clothes, you can have your medicine, everything is online. And there is no border now for that purpose. Sitting here with a mouse, I can make an order, place an order in London, I can place an order somewhere in New York, get the goods delivered. And if that happens, now each country is to try to find out where is my tax on that income which this gentleman is giving to the country. That's a challenge which is coming up over a period. That's the digital economy which is creating a problem. And now this has opened up a new Pandora box for each of the country. And in that process, I was just wondering, as I started at the beginning, each country has a sovereign right to tax. Now what the new world is going on is, each country has a duty to levy tax. You will be wondering now what we call this discussion, pillar 1, pillar 2 discussions are going on, where are people, the countries are after those countries which are not taxing income in their country, asking those corporate, please tax it. And how this debate has started. How this debate has started. You know the multinationals operating in America, Apple, maybe Google, and maybe et cetera, and those operating in getting Netherlands, Ireland, and working in Luxembourg, registered somewhere, doing business somewhere, mouse is being pressed somewhere, income going somewhere, no taxation. And now the shoe started pinching. And who were the countries, which were the country got affected? Germany, France, all those countries got affected. And then they approached the European Commission, look, this is not correct. Our people are paying this money income is going to Luxembourg, Netherlands, etc., and we are not going, and then European Commission come in the way, ki, all right, this is wrong. And when this issue was being examined, interestingly, who was the defendant? Which country was arguing for the corporates? None other than USA. Why? Because the moment that income get taxed in those countries, USA will lose the tax because double taxation avoidance agreement immediately will come into operation. If these corporates have paid taxes in Europe, then America will be duty bound to give credit to these corporates in country, and America will lose the taxes. Now, this has opened up a new paradigm and what we call a new global era of taxation, where an income, you never know where it is generating and how it is generating. And then the need of the hour as on date, if I look at it as a larger perspective, is now double taxation avoidance agreements are not going to help it out. It is going to be a multi-country arrangement where all these countries come together and have an arrangement to make the tax law clear and simple for the taxpayer. The taxpayer has no issue, it will paying taxes. It is the tax administration and the taxing government, they have to come to a new model, how to balance this out, which pie, out of the pie, which money, how much tax will take one country and how much tax will go to the other country. That's a new global era of taxation which is going to be on the economic front where the challenges are coming up on this issue. Because the topic which I said here is that how you are going to divide it. The world in the future is a digital world. And there's another area, which is another thing which is going to happen soon on this part is, earlier we were all in a feudal system, by and large corporate houses being owned by one family, one corporate business, etc. But over a period, the way the landscape is changing of the corporate and the private equity investor and other investors coming in, you will find it difficult which corporate is owned by which group. And there are now interesting issues coming up, even in the courts, that when we say, no, this business, this corporate house is owned by this, and sometime a relief is sought against that corporate house, the challenge comes up, even if you give a relief, who is going to suffer? Now take the case of a real estate company. Normally when a real estate company, it defaults, and some of the people who have booked flats, etc., and then they come forward and make a prayer to the court that they must be given concession or something happening it up. The moment court intend to give concession, the court find that this concession will go against those people who has contributed to that company through mutual fund by the private equity players. So they have to achieve a balance out of these issues also. Now, in this way, this socio-cultural connectivity in the new era of taxation will need to be addressed, because what we are looking is not the past, where land and physical goods were the main contention on which the tax was there. Now it will be a digital. You never know which money coming from where and where it is going out. That's a challenge which I believe the economy, opportunities are the new scenario is going to develop on that part. And in that direction, now the two issues which are emerging, mainly two issues are emerging, which I say. One, now sovereign right, instead there will be a sovereign duty to tax. And that's why middle class countries and many countries which do not have the taxation, now they are being asked that you please introduce a corporate tax which is at least 15%. The purpose is that my base erosion does not take place, and many of the corporates which operate in other part of the world will be duty bound to fall back upon to the home country, believing now that there is no benefit if I go to that country, I will come back rather to my country and pay taxes here, because that's a tax-free holiday will go out on that part on this issue. That's a new scenario which is getting developed. And similarly, how to going to divide the digital part of the world on this issue, that's going to be another challenge which is coming up on the scenario on this part. Now, India is also not immune to all this development happening. We did introduce equalization levy way back in 2020. There are many challenges which has come up on the equalization levy, but as we see the talks are progressing, probably equalization levy will get taken care of by the Pillar 1, which is likely to be introduced by 2023. But one thing which will be now very important is that taxation will have to be by consensus rather than by way of as a sovereign right. We need to have a stakeholder consensus where not only the government of the day one government can decide that it is my right the way I take it. And if I can draw a parallel on direct taxes from something which happened in India in 2017 when we had this GST. We in India, we know that we are a union and we are a federal also. And each state government had a right to levy tax on goods under the old law. Earlier used to be the sale tax, then came the value-added tax, and now in the GST. And he achieved a consensus that all states now will have a GST council. There will be one country, one tax and uniform law. I look forward to a day when the world over, looking to the digital economy the way it is growing and the way the things are going on, there will be one tax across the globe, same rate, to be divided by different countries in a formula to be arrived at a consensus by the OECD or otherwise. That can be one of the best model India has shown to the world that look, GST council, the way it works, there is a one rate we decide, each state has to follow it. And how much division will take place, who will take it place, that's also an important aspect. Because in GST also there was a big challenge. Because earlier, if you just, because you are all professionals, you can appreciate that, tax was being levied, sale tax and VAT by and large were on the producing state. Manufacturing state, they were getting benefit. And now with the GST coming into force, the benefit goes to the consumption state. Where the goods are being consumed, that state get ultimate collection in the GST. Similarly, in direct taxes and income tax now as on date, wherever the company was sited, located and where the income was accruing, that was the place which is the income being taxed. But now in the digital world, people are asking, look, gentlemen, a person sitting in India and Delhi clicks a button, uses an IP address from Delhi, but he buys goods from a New York Mark and Spencer showroom. That Mark and Spencer is making profit. Why India should not get a tax out of it? That's how the development is coming up. So this is the new scenario which is getting developed, and I am reasonably hopeful that over a period, maybe not a very near future, down the line, 5 year, 10 year, we can look forward to one nation or one word and one tax on this new interconnectivity. With this, on behalf of the organizers, my apology that Mr. Hari Salve has not joined, and I was asked to talk about on the direct taxes. Now, time permitting, with the permission of the organizer, there are a few questions which has come on the, I think, GST, so I like put to Mr. Datar to clarify some of the issues. Thank you, friends. Is that a few questions I can... one of the questions which has come from Mr. Just Modi is, isn't there need to reform tax laws to promote socio-economic growth and encourage not only the corporate but also other taxpayers to contribute toward SDG, socio-economic growth? This is the third question.
See, my answer is you require reform tax laws just to promote economic growth. The social part of it will follow. I've always believed that the fundamental problem, in my opinion, after so many years of tax, is that the tax laws operate in an independent silo. The focus is on revenue maximization rather than growth maximization. You keep levying tax irrespective of the impact on the economy. Like Vodafone, the judgment came, you make a retrospective amendment. It has huge negative impact, which nobody considers. Same thing in GST, you keep on levying tax just to maximize your revenues and so on. So I think the need is to reform tax law. The first thing is to abolish revenue targets and take tax laws not just in the perspective of tax, but the entire country. Once tax laws promote economic growth, socio-economic justice will automatically follow.
Just a bit. Just to add, but I think Datarji had said it, See, there are reform in tax laws to promote socio-economic growth and encourage not only the corporate but also other taxpayers to contribute to socio-economic. I believe that's already part of the statute on that issue. And now and there's another question for Mr. Datar. Are we still looking at having a direct tax code in India? Will that not simplify taxation structure? What are your views on direct tax code?
Yeah. See, I'm now this screen has gone now. This was anyway.
Yeah. I may just said Mr. Arvind Datar is also very popular amongst all of us as a direct tax advocate and have been regularly appearing in direct taxes. His specialization is not only GST, in all tax matters. So I will leave it to him all to answer this question also.
Yeah. No, on this question of direct tax code, I think direct tax code is not necessary at all. We are happy with the Income Tax Act. There is a feeling that if you change the law, there'll be simplification. It's not going to happen. It's not happened in the Companies Act. It's not happened in GST. First, my old senior, late senior who passed away, he said that a simplified tax law is very difficult to achieve unless you have a flat tax system. Only if you have a flat tax regime, which was introduced in Estonia and some other countries, where whether you're a partnership or a business, etc., everybody pays 11% or 12% tax on your profits as per your P&L account. That's all. There's no other question of having first take the P&L account, add something, reduce something, MAT and etc., no problem. And whatever direct tax code I've seen, it is nothing but the same Income Tax Act put in a different form. I asked myself the question, if you have a new direct tax code, what are you going to do? Are you going to abolish capital gains? What about profits and gains from business? In fact, one idea which I don't know if I can put it to chartered accountants is that I don't know why we can't have just a tax on the P&L account of a company, of listed companies. Is that possible or not? And I was arguing a case in the Supreme Court, and one person told me that 97% of our tax collections come from TDS and advance tax. So the entire litigation, Mr. Ved Jain, me and all, we keep arguing only for that balance 3%. So answer question, no need of direct tax code. Let the income tax be there. Just eliminate the unnecessary provisions of the Income Tax Act.
So there's another question for you. I think this will be much more relevant for all of us here. Can you just brief about extraterritorial operation vis-a-vis the extraterritorial legislation? I hope everyone understands this question. This is regarding extraterritorial operation of a one country law in other country legislation.
See, extraterritorial operation and extraterritorial legislation. I'll be dealing slightly with some legal points. Please bear with me. I know lunch is waiting you, but just Article 245(2) says a law will not be unconstitutional because it has extraterritorial operation. Now, operation outside India, the word is India. Now, if you take the history, Article 245 is borrowed from Section 399 of the Government of India Act. Government of India Act defined not India but British India and said that any law made in British India, that is the Madras Presidency, Bombay Presidency, will not be valid even though it has operation over territories where we have suzerainty, that's over the princely states. So the law was never that British India could levy taxes on things happening outside British Indian territory. I'll give a simple example, which I argued this point in the Mohit Minerals case before the Supreme Court, but it has not been dealt with, the ocean freight case. If you take the Customs Act, Section 1 says, the act shall apply throughout the territory of India. All of you see, any act will say it applies throughout the territory of India, Section 1 of the Income Tax Act. There is one act, the Territorial Waters and Maritime Zones Act of 1976, where there is no such provision. It does not say operate in territory of India. And there they define what is territorial waters, what is coastal area, what is exclusive economic zone. Now the system which they do to levy tax outside the territorial waters is, central government is empowered to issue a notification that an oil drilling rig, say like in Bombay High, which is outside the 12-mile limit, but in the EEZ, within 200 miles, you have to first declare it to be Indian territory, and then it will be subject to customs duty. Now, extraterritorial operation means the law is territorial, but it has effect outside, like Section 9, deeming fiction. But extraterritorial legislation means Indian Parliament passes a law seeking to levy tax on a taxable event happening outside India, like the ocean freight. Freight in Germany, Japan, etc. is sought to be taxed in India. That is a classic example of extraterritorial legislation. Now, those of you who are interested, this has been discussed in detail in Bengal immunity case. Before CST came by the Constitution 6th Amendment in 1956. Before CST came, each state started levying sales tax. Now, the theory is, as long as there is a nexus with the transaction, that state or country can levy tax. So in the Supreme Court judgment, they say, since the goods are sent from Germany to India, transported partly in Germany, ultimately it's received in India, there is some nexus with India, so India can tax. GVK Industries, they say, as long as there is some nexus, you can tax. So in the old days, goods will start from Madras to Bombay. Because the goods are starting from Madras, Madras can tax. Because they pass through Andhra, Andhra can tax. Because it's delivered in Bombay, Bombay can tax. So this led to multiple taxation. And Justice Vivian Bose likened it to a dog attacking a part of the meat, different parts of the body. So he used that particular expression. Ultimately, that was solved. So according to me, extraterritorial legislation is not permitted. Only extraterritorial operation is permitted.
Thank you, sir. And our discussion will not be complete unless we talk about cryptocurrencies. So there are two questions on the cryptocurrencies. How the tax regimes handle across the different jurisdictions where the cryptocurrencies occurs. And what about taxation, both in direct and indirect on cryptocurrency and challenges attached to it?
Well, cryptocurrency, I think in 194S it is called virtual digital asset, right? The current controversies are on what do you levy tax. In GST, the other major problem in India is, like one matter is just, we finish in Karnataka, on online gaming. Now, do you levy tax on the gross amount or on the charges? You see, what happens is, I'll come to cryptocurrency, same problem comes in cryptocurrency. There's an online service provider, an e-commerce operator. Let's take online gaming, Rummy is played or some game is played. 20 of us get together, we deposit 1,000 rupees each. So 20,000 is the pool. 2,000 rupees, 10% is collected by the platform operator, the e-commerce operator, as his fee. And the balance 18,000 will be divided amongst the winner, either first prize, second prize, etc. Now the controversy is, do you levy tax on the entire 20,000 or on the 2,000? So of course, one major point is, if it's a game of skill, it can't be gambling. The law in India, in fact, one point which I argued is, if you play Rummy, it is a game of skill, it is not gambling, even if you play for stakes. If you play poker, you play flush, it is gambling because it's chance. There is a Public Gambling Act of 1867. And Section 12 of that Act says, nothing in this Act shall apply where it's a game of skill. So if you bet and play a game of skill, it is not gambling. Now in cryptocurrency, what happens is, there are basically two transactions, spot transaction and P2P transaction. Now when the crypto is exchanged, say a person sells bitcoins and buys some Ethernet or whatever the currency, and now after the FTX collapse, I don't know how far, what's going to happen to cryptocurrencies. But anyway, the major controversy is, do you levy tax on the fee charged by the platform or on the gross amount? As far as 194S is concerned, it says any person responsible for paying consideration on transfer of a virtual digital asset. That's the language of 194S. One question that arises here is the exchange liable to pay the deduct TDS? Now, most exchanges are abroad. One interpretation is a person responsible for paying consideration on transfer of a digital asset. Now, if I I have a transaction with Mr. Jain on cryptocurrency, say on a German exchange or a British exchange. The British exchange is not responsible for paying money from me to him or him to me. So one view to be taken is, if it's a P2P transaction typically, there is no liability of TDS against the crypto exchange. It's only in the case of a default and a spot transaction, I don't want to get into bylaws and so on, where you can make a claim against the exchange because they have got that wallet. But this is the law as far as cryptocurrency is concerned. It's just introduced now, so let us see what happens eventually.
I may just add what Mr. Arvind Datar has said is, as I said, the taxation laws have been used by the various sovereign government to address various issues arising through the tax policy also. And if you look at, when I was explaining that there various incentives were introduced just to encourage particular industry, similarly, under the Income Tax Act, various disincentives have been provided earlier also to discourage particular type of activity, to discourage particular type of industry. If you look at an industry is not environment friendly, if the industry is particularly like alcohol, tobacco, etc., the rate of taxation has been quite high only to address what we call social issue or at the same time, sometimes political issue. I believe the dilemma of the day, I think with the regulator or the administration or the government is the cryptocurrencies, there is no clear thought process, whether it has to be legitimized, whether it is the need of the hour, whether the economy needs it or not. And that's why the tax laws, particularly the amendment which has been made by the Finance Act 2022, have been used as a measure to discourage that people do not venture into transaction with the cryptocurrency. That's why you will see the 115BB, there's a high rate of tax, no deduction of the expenditure, gross amount being taxed. So this goes with the topic I say, a new global economic era, a taxation era, where what we are trying to use political, socio-cultural interconnectedness. So some of the tax laws or tax rates are worked out in a manner not only to encourage, but also to discourage one particular type of nature of transaction or value on that basis. That's the idea, believe it also. We have in GST also an example where we say certain goods we call the sin goods, where the tax rate is high and the cess is also put very high. That's one of the objectives. And cryptocurrency as on date, if I believe in direct taxes, the tax rate and the deduction, denial of deduction and TDS, etc., are all meant only to discourage people to venture into the cryptocurrencies so long the government does not come out with a clear policy what will be the cryptocurrency on that bill. I believe that's it.
Yeah, to supplement what Mr. Jain said, those of you interested in understanding cryptocurrencies, there's a superb judgment of the Supreme Court of India in internet service provider, that internet mobile one judgment is there by Justice Ramasubramaniam, I don't know the whole course title, where the entire history of cryptocurrency, the role of RBI, what's the law in different countries has been discussed. So you'll get at one place the entire law on cryptocurrencies. On socio-economic growth, one more issue is pending now in the Supreme Court. It will be heard shortly. I've got it referred to a bench of 3 judges. You see, you talk of socio-economic growth. Now you announce a scheme for development of Northeast region. So if you set up a place in Tripura, Baddi, Himachal Pradesh, etc., you get full tax benefits. Income tax benefits, excise benefits. It's for 10 years. So you put up a plant, you spend 100 crores, 80 crores. In the third year, they say, you're making cigarettes or you're making some antisocial thing, I'm going to disallow the benefit. Now the question is, when you announce the scheme, you made me invest, halfway through can you change it? Because there's no estoppel against the legislature. So it's a major issue the Supreme Court is to grapple with. And the paradox is the income tax benefit continues, the indirect tax benefits. So what is your policy on socio-economic growth? And what we are saying is, when you talk of socio-economic growth, is employment more important than cigarettes being manufactured? The whole balance is there. You set up an industry in Tripura or Mizoram or Arunachal Pradesh, you generate employment. One part of the scheme is you reinvest the money in some social purposes. So these companies have started schools partly, and suddenly the government withdraws the scheme. So when you talk of socio-economic growth, if manufacture of cigarettes is going to generate employment, then which is the larger public interest? What happens when there are competing public interests? So these are all interesting issues which are going to come up before the court.
Just a last question, we can take it looking to a time constraint. Free zone area around the globe and effect of taxation in general because of these freebies. Free zone area around the globe. The globe.
And effect of taxation? Frankly, I've not understood the question. What is a free zone area?
Yeah. I think the question basically is that now looking to what I think a pillar 2 they are talking about is that each country need to tax, have a minimum tax, particularly corporate rate. And what is the scenario likely to happen in the free zone area where like in Middle East or Luxembourg, etc., you need not have to pay tax. In India also we have some free zone area, 10A, 10B used to have that area. The objective is to find out what is going to happen in future. I think the way OECD is coming up and they were trying to identify the country one after the others, because option available, like the UN puts a sanction in case one doesn't follow the international law. The other option is the way we did with the Cayman Island, that in case they do not follow the secrecy or they share the information with India wanted, whatever the transaction you enter into with the Cayman Island, that will be taxed at the maximum marginal rate, forcing that country and forcing people doing transactions with that country to be more transparent to share the information. Similarly, as I look at the Pillar 2 coming into force, now all those countries which provide these types of incentive, free zone area, no tax, etc., will have no option but to follow the same model which we have followed in GST. You will see that before GST was introduced way back in 1st July 2017, various state government, in order to encourage one particular industry area, etc., were giving concession, tax holiday, return, etc., something like this. After coming into force, now those concessions are not available. The only option available to the state is to provide that money back by way of cash incentive. So now all these countries will have to put a tax in those areas. They will not be free zone area, but what the country can do is that in order to encourage that industry, they will collect taxes, but then they will give a cash incentive or cash subsidy, something like this, to those particular industry. I think that will get substituted once across the world tax is levied. But when we are talking of these taxes across the world, we are talking only of corporate, not of individual. So individual taxation will continue to be immune and outside. Present discussions are all going on is regarding the corporate taxation on that part. So because mainly corporate contribute the major chunk of the revenue which comes to East government. If you look at the statistical data across the globe, the major revenue is coming only from the corporate taxation and personal business taxation, not from the personal taxation. So that's the idea basically. But as I said in the beginning, on that part, human mind is fertile. So people go on inventing the new weed, how to save the taxes, and the tax administration goes on finding out how can I extend my area, and which we always call a human mind is imperialistic. I want to increase my area, the other one wants to encroach upon my area. This tug of war is going on and will continue to go on till such time we are able to achieve some consensus. What I said, consensus taxation will always be one of the best taxation if we can follow in the world. But looking to the situation, political or otherwise, it may be very, very difficult to achieve a consensus that across the globe we have one tax and one system where we say that this particular type of tax will be there. And if a country wants to encourage or promote one particular industry or area, then it has to incentivize that area not by way of tax, but otherwise. That's a way we can look forward to on this issue. But this digital world, with digital business is going to be the future, and nobody can work it out. And with that, if I can just give an example, digital world is just like air, water, and bird. If you look at these three things, air, water, and bird have no boundary. In Hindi, if I can say, पानी, पवन और पंछी, तीनों की कोई सीमा नहीं होती. पानी एक कंट्री से दूसरे कंट्री में चला जाएगा, पंछी चला जाएगा, हवा चली जाएगी. Water, air, and bird, you can't stop it. Similarly, the digital world, digital economy, nobody will be able to control it. It is going to be borderless, and there will be no limit. Only thing is how you want to achieve a consensus that after crossing the boundary, who will have the right, how much tax you will collect. Similarly, if you have a water flowing from one country to another, you can't stop it. You make a barrage, you do all of these things it also. But at the end of the day, you have to achieve a consensus, what will happen. Same thing is going to happen. Pandemic, this COVID-19 has shown us the way the world is going to develop. Everything will be on a mouse or a button, and every transaction will be there. You can buy, you can sell, and you can do whatever it is. And it is the IP address which is going to decide which income, which part of the world, who will tax it, and in what manner will tax it. That's the way I look at it. Yes, please.
I just want to share one thought. I've always found it that as if not levying a tax is some kind of great sin. Like Mauritius, what is wrong if Mauritius doesn't levy tax? Nobody sees what is the use, how useful Mauritius has been in developing the telecom sector. We give exemption, but there's so much of employment generated, wealth creation by having a particular country which doesn't have tax. Ireland, 90% of aircraft leasing is to Ireland. So what is wrong with it? I mean, this entire theory that everybody must tax 15%, on a basic principle, I don't see what's wrong with it. Brits, when we did an important case British Petroleum had 136 subsidiaries throughout the world through Cayman Islands and so on. But if they're able to generate so much of employment, wealth, etc., throughout the world, I don't see what is the great difficulty in having this. And the people who keep complaining continue the treaties. Nobody has cancelled this treaty for double taxation. Nobody has scrapped Mauritius. You may have some grandfathering and all, but then it is very useful to you. So I don't know how far this is going to generate. And even this pillar 1, pillar 2 with 20 billion, 10 billion, etc., I don't know if it's going to really work. What is the great difficulty if one country doesn't levy tax? Why is so much of song and dance about it? Look at the overall impact to the whole global economy.
I think there is clear consensus that we can go on and enjoy listening to both the distinguished luminaries from the taxation world. Please let them know. Thank you very much. I'd like to invite on stage CA Vishal Doshi, respected Central Council member, ICAI, to felicitate CA Ved Jain, past president, ICAI. Thank you very much, Ved sir. Your thought of taxation by consensus, not necessarily as a sovereign right, is very profound. Let's see how future goes as regards taxation. Thank you. I'd like to invite CA Rajendra Kumar P, respected Central Council member, ICAI, to please come on stage and present a token of gratitude to Mr. Arvind Datar, a renowned senior advocate. Thank you very much, Arvind ji, for all your thoughts today.
Chennai Express.
Thank you very much. Thank you.